pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine partners.
My bitch a choosy lover, never fuck without a rubber. Never in the sheets like it on top of the cover. Money on the dresser, drive a compressor. Top notch hoes, get the most, not the lesser. Trash like the buck for $40 in the club. Fucking up the game, bitch, it gets no love. She be cross country, giving all that she got. 1,000 a pop, I'm putting business off the lot. I smashed up the gray one, bought me a red. Every time we hit the parking lot, we turn head. Some hoes wanna choose, but them bitches too scary. Your bitch chose me, you ain't a pimp, you a fairy.
A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine partners.
Baby, you been rolling solo, time to get down with the team. The grass is greener on that other side, if you know what I mean. I show you shit you never seen, the 7 wonders of the world. And I can make you the 8th if you wanna be my girl. I say my girl, I don't mean my woman, that ain't my style. Need a real street stalker, walk a green mile. Keep piling up the paper on the dining room table, cause you able to realize I'm the truth and not a fable. Baby, rockin' Russian sable, keep that chiller on the rack. What I look like with some $1,000 shit up on my back. I'm a $1 million man, they need $1 billion bitch. Put my pimpin' in your life, watch your daddy get rich. Easy as ABC, simple as 1, 2, 3. Get down with UGK, Pimp CBU with B. Cause what's a hoe with no pimp, and what's a pimp with no hoe? Don't be a lame, you know.
Hey, what's going on, everybody? It is Artie of Artie's Corporate Fiction. Happy Wednesday to all of you. I am tired. I will admit that straight up right at the outset. I really did not like fully wake up today. So it's been sticking with me all day long. But I'm here as promised. But I will be able to react to this video. I want to first give a shout out to Bigen the second. Oh my gosh, I completely forgot to put his stuff in the description. Bigen the second actually gave me access to this video for sure. So I want to thank him first and foremost, and appreciate his diligence in looking at these videos and finding some interesting cases. I actually specifically asked him to see if there's any like support / custody cases that were of interest, and he gave me these 2. Whether we go to both, I don't know. I hope we can. The first one does have some moments that I think we can skip. They're not exactly very interesting, and they're not very germane to what makes them an interesting case. So we might be able to get to both, but we'll see. If we don't, or if we get close enough to time, I'm gonna try and stop at the end of the first one, and then we'll save the second custody hearing for a later date. But we're gonna keep the Polyaudis trial and body cam footage extravaganza for Friday. That's still gonna be set for Friday. So thank you very much, guys, for being here. Thank you very much for all of your support. Let's get right back to it. Get into the main screen. So this is a motion to hold the father in contempt of the court's order for child support. He is behind on his child support. I won't spoil the amount, but it's not low. Let's put it that way. And the father is also apparently is pro se. The mother is represented by counsel. So we're going to get started right there. All right. By the way, guys, please, while you're here, I appreciate it if you hit the like button. Check me out on Twitch if you haven't, if you care to. If you don't, that's perfectly fine. And check out my Discord, of course. All right, let's get started. This is also in Texas, in the Dallas area.
On DF 0411968. Mr. Finkentraman,
Yay, Greasy. Thank you for the membership.
on
Yes, sir.
Monday, on the Monday of this week, at the beginning of this hearing, I provided you certain rights, or advised you of certain rights, including the right to remain silent, the right to refuse to testify, and your right to representation by counsel. Those rights still apply. The court does want to clarify one thing for the record. I've read your petition for writ of mandamus before the Supreme Court, which was denied. In it, and I will chalk this up to sloppy language. You suggested this court said you no longer had a right to be represented by counsel. This court never made such a statement.
All right.
The court, in fact, continued the November 29, I believe that was the date, proceeding in order specifically so you would have time to obtain counsel.
And I would like to remind the court that I mentioned the court on the same day that that's too short a time period for me to get competent counsel. Just to add to that, I did attempt to get even reputable individuals, one of them being Brad Lamugis, whom you're aware of, is a reputable attorney in the trial and appellate courts. And he said there's no way he can appear today with such short notice. Yeah.
All right. I understand that. I also understand that you have had, I believe, 5 previous counsel in this matter. It's time to bring this to a conclusion. You've had sufficient time to employ counsel. This is not that complicated. It's a motion for enforcement. Mr. Skinner.
Just one more thing, Your Honor, if you don't mind.
Yep.
I'm still below the weather, and as you can tell, in fact, I was coughing right through, and I think somebody muted me. And so I believe there's a provision under Rule 251 of the Texas Rules of Procedure. And there's also a case citation for that. If a party is below the weather, then the court has the discretion to grant a continuance. Citing case Briscoe versus Instruments, which is number 17-14-00141-CV, Texas Appellate Court on April 6, 2016. I just want to bring that to your attention. It's entirely your discretion, obviously. And
all right. So for the first thing I did notice was like, he's been continuing this case for a very long time. This has been a very, very long case, and that you'll find out, with you'll discover later on. But I really appreciate the moment he talked about him being under the weather is when he decided that's when he started to get those fits started.
That case is cited, and that case cites another case for that, and that case being Pena versus McDowell, which is 201 Southwest 3D 665 667 Texas.
Can you repeat the case?
Sure. Pena, Pena versus McDowell, McDowell, 201 Southwest 3D 665, 667 Texas 2006. I'm just citing, this is case cited by Briscoe's Investments, where it talks about possibly the court having discretion to continue for parties if a pro se party is under. So I just want to bring it to your attention. But having said that, if you compel me to continue, I am not.
Hey, shout out Bigen's in the chat. Hey man, again, shout out to you for sending me this video. Both cases pretty interesting. So I really appreciate you sending them to me.
Giving my rights to an attorney, but I will continue under duress.
Okay. Considering that an oral motion for continuance, the court will deny the motion. Mr. Skinner, call your first witness.
Judge, is Mr. Vicky Trauma going to testify or not?
I was actually listening to this more so than watching it. I didn't realize that her attorney started out the camera like this with half his face missing.
I don't know.
I would call him as a witness then, first witness.
All right, Mr. Venkatraman, you've previously been sworn, but out of an abundance of caution, I will I'll swear you in again. Please raise your right hand. Do you solemnly swear or affirm that all testimony you will give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do, and Your Honor, I request an opportunity to make an opening statement.
Judge, if he testifies, he can't quit. He doesn't get to pick and choose when he wants to testify.
That's fine. That's not what he asked.
I just said I want to make an opening statement, and I will testify. Yeah.
All right.
Can I?
1 second. Please state your name, witness.
Sure. My name is Venki Venkatraman.
Mr. Venkatraman, welcome to the 256th District Court. Now, Mr. Skinner, I was going to blow past opening statements because I don't believe I need opening statements, but Mr. Venkatraman has requested an opening statement before he testifies, and I will grant him 3 minutes to make an opening statement.
Thank you, Your Honor. Can I proceed?
You may.
Hey, Jadub, thank you for the 5 gifted memberships.
Your Honor, I would like to mention to this, just to give the background, which you're already aware of. I know you're very fastidious, you read everything. So this court case order that is being attempted to be enforced was signed in May of 2019. I then appealed it right away to the Dallas Court of Appeals, and I posted a superseded bond along with it. And at the same time, I also conferred with the Attorney General's office right from the outset with respect to the child support arrearage. And I will keep chanting Associate Attorney General like a mantra here because I've been in constant touch with them right through this whole matter. They agreed that as long as there's an appeal pending and a superseded bond was posted, I did not have to make any payments, and they will not be the ones trying to enforce anything because they still have an appeal going on. Further to that, I again conferred with the Attorney General's office at the highest level, Kathy McMichael being the head of the Child Support Division, as well as with Melissa Smith, who reports into her, regarding after this motion for enforcement was filed, what would their position be on this matter? What would they recommend I do? They said that your court order says on page number 24 that you can pay $1,045 a month. And that would be satisfactory as far as they are concerned. They are also aware that the appeal is not yet over and no mandate is issued. But after conferring with Ms. Smith, Melissa Smith, I started paying $1,045 per month, which is what the order says on page 24. It says, it is further ordered that if Venki Venkatraman is not paid his judgment for child support.
Oh, I just now saw Dummy Kruger in the chat. Dude, I love your channel. I think I've told you this several times. I just watched your latest video today, which was pretty awesome too. So guys, if you haven't already checked out Dummy Kruger, please do so.
Arrearage in full before the termination of his child support obligation is caused. Venki Venkatraman is ordered and shall continue to pay the judgment by paying $1,045 monthly on the first day of each month thereafter until the judgment for child support arrearage and all accrued interest is paid in full. This is known to the Attorney General's office. Based on this, I was advised to start paying that. I started paying that. So I believe I'm in complete compliance with the order. And what Mr. Skinner is seeking is actually a modification. He's looking to override this order and have the entire arrearage paid in one lump sum. I believe that's completely uncalled for. The whole motion is frivolous. And also the fact that he's asking that the superseded bond should be awarded to him before the appeal's over, that you've already ruled on September 15 that you cannot do stuff like that till the Supreme Court issues a mandate. He's also seeking to suspend my driver's license by misquoting the statute. The statute 232.003 says that you may do it, and that also it has if it shows that I failed to comply with the repayment schedule. I'm already in compliance. So I just want to conclude the opening statement by saying that this is a frivolous motion just for the sake of harassment and trying to not for any genuine reasons as far as I'm concerned.
Thank you. All right. You have been called as a witness, Mr. Venkatraman. You have been sworn in. Mr. Skinner, he is your witness.
So if you weren't able to glean what he said, he's trying to argue that he's actually been in compliance with the order, but at the same time, he said that while he has been trying to appeal the child support order, he did not he was told, or he claims that he was told by the Attorney General's office that he did not have to pay child support while the appeal was ongoing. Further, he also said that he put up front a supersedeas bond pending the results of the appeal. So he says that this whole issue is not a motion of enforcement, but rather he wants a modification of the child support.
Yes.
In other words, the petition, the mother, is not asking for enforcement of the existing order, but rather she's asking for a modification.
Mr. Vicky Trauman, you were court ordered to pay an arrearage, is that correct?
It wasn't. It was under appeal. Yeah.
Okay, but you were court ordered in May of 2019, and this was a trial from November of 2018, correct?
So November 2018, I believe. Okay, based on the timestamp that Bigen gave me, this hearing's December 2022. So this has been a 4-year ordeal.
Okay, but you were court ordered in May of 2019, and this was a trial from November of 2018, correct?
The order is, I think, from May 2019.
Okay,
After
but
all the various,
the trial occurred in 2018.
Don't talk.
Yeah, Skinner's getting a little bit too zealous here. Needs to walk it back.
Talk over the witness, Mr. Skinner.
Did the trial occur in 2018?
I do not recall exactly the date of the trial. The only thing I recall is that the order, after various motions were all filed for reconsideration and other matters, was signed in May of 2019.
Okay, so you were on May 6, 2019, you were ordered to pay child support.
That
Correct.
order had on page 24.
Is that a yes or no, sir?
It was yes, of course, yes.
Okay. Did you start paying child support in May?
Much rejoicing.
Thank you, Archangel Third, for the $50 super chat. Wow, thank you so much, Archangel. I appreciate it, man. But you do know the jump scares are still $100, right? If you're trying to do trying to do a jump scare, it's $100. Enough. But thank you very much for the super chat.
Yeah, 2019.
I did not, because in May 2019,
I appreciate
filed
it
an
nonetheless.
appeal and
Thank you,
posted a
man.
supersedes bond for the amount of child support that was due till that date.
Did you approach the court and ask them to set your appeals bond?
No, I did not. I approached the Court of Appeals and clarified with them with respect to in my docketing statement, which you have a copy of.
Did you contact Judge Lopez and ask him to set a supersedeas bond?
I did not contact Judge Lopez, no.
Okay. And the full amount that you were court ordered to pay in the arrears was $15,215. Is that correct?
$15,215 appears to be the arrearage at that time.
So at the time, so in 2018, or excuse me, at the time of the order of May 2019, he owed $15K. You know what? That's actually a good poll question. I'm going to put that in chat. How much do you think he owes now? I'm going to make that poll. Let's see. Put 23K. 30K. No, we're gonna make it less obvious. 31K. Or 34K. Closest number. It's not the exact number, but closest number. Or let's put it this way: greater than 40K. How about that as the last one? I'm gonna ask the chat.
Yes.
Okay, and then you were court ordered to continue paying current child support. And beginning in, it would have been January of 2018 of $895. Is that correct?
I don't think that's correct. That's a misstatement.
You sure that's not what it says in the order?
We are not using Price is Right rules. It's going to be the closest relative, whether it be higher or lower. It's going to be the closest relative is going to be the correct answer.
Pardon me? Is that a question?
You were not ordered to pay $895 a month beginning December 1st of 2018.
That's not an accurate statement. The number is correct, but the date is not correct.
2001 of 2018, you were not ordered to pay $895.
Is that a question?
I'm asking you a question. Yes. Were you court ordered to pay $895 beginning December the 1st, 2018?
$895 a month is correct, but that $895 amount started from the date when the first child emancipated, and that was way back in June of 2017.
I don't think you understand the question, Mr. Becky Trauman. The court order we're talking about is the one that Judge Lopez signed May 6, 2019.
Mm-hmm.
Correct.
Is that right?
Mm-hmm.
Judge, would ask you to take judicial notice of that particular court order.
The court takes notice of the May 6, 2019 order signed by this court.
Okay. Were you not ordered to pay $895 a month?
$895 is the correct number, but the date you mentioned was not the correct date.
Well, I'm looking at Mother's Exhibit number 2 that was entered by the court, which is the activity report from Attorney General.
Your Honor, I need to object to any exhibits that he presented.
Okay, Jassa, I forgot. I gotta sometimes, because I'm so used to these terminology, I forgot that it may sound different to people. But Jassa, you make a good point, because oftentimes when we hear the term emancipation, we're thinking Emancipation Proclamation. Emancipation just simply means that the child has either reached the age of majority or that they are out of the house, or generally that they're out of the house. But the emancipation can be a hard rule at age 18, but it could also mean that there are circumstances involved that would allow them to say that they are no longer reliant upon. Archangel, thank you for the $100 super chat. I hope you got your money's worth. What was I completely forgot what I was going to say. Yeah, emancipation can also be a factor based declaration by the courts as well,
which were not sent to me with 24 hours ahead of the hearing. The court rules requires that all exhibits are sent to the other party within 24 hours of the hearing. I have not received a single exhibit from him within 24 hours. I have no idea what is he talking about.
Well, I'm not going to consider a blanket objection to exhibits. I will consider them one at a time. The only thing that has been referenced here so far is Mother's Exhibit number 2, which this court entered, which the court admitted on Monday.
Okay.
That's what I'm trying to do, Judge.
I recollect that, and I also mentioned at that hearing that this is the same as my attachment to my objection of page number 183 in my objection, this second supplement objection that I filed. If it's identical to that, then I absolutely agree that's accurate.
Okay,
because
so
it's certified.
You're not disputing the accuracy of the Attorney General pay record?
Oh, not at all, no.
Okay, and it states that you should have paid $895 beginning December 1st, 2018.
Yes, it does.
Is that correct?
That's what it says, correct.
Do you dispute the accuracy of the report?
No, I don't.
Okay. And how about January the 1st of 2019? You were supposed to pay $895. Correct?
Yeah, that's what it says, correct.
And December 1st, 2019 says you're supposed to pay $1,045. Is that right?
That's correct. Yes.
May the 1st, 2019, $1,045, right?
May the 1st. Okay. I'm sorry. I'm sorry. I got to disagree with you there. May the 1st, the spreadsheet says I had to pay $895, not $1,045.
Okay, May
In
1st,
fact-
2019, the AG's report says you're supposed to pay $1,045.
May 1st, 2019. I'm not sure what it means, but it says transaction amount 1,045, amount due $895. So I just want to clarify to the court there are two amounts there. And I'm agreeing that there are two amounts. There's one amount which says under transaction amount, it says 1,045. And under amount due, it says $895.
Okay, did you ever make any of those payments?
The only payments that got made,
Yes or no?
yes,
You made payments?
there were two payments made into the record. It's in the record right in front of you.
Up through May 1st, 2019, did you make any payments?
My God.
May 1st, 2019. If you answer questioning as generally, have I made child support payments? I have made child support payments continuously starting 2005, April till 2017, June.
He's not asking about that, but
Because that was the time
You haven't made it. You did not make any payments December 2018 through May 31st, 2019. Is that right?
December 31st, 2018 till May 31st, 2019. No, I have not made any payments. No.
Okay. Did you make any payments in June of 2019?
In June of 2019, I did not make any payment. No,
July of 2019?
no, I did not make any payment.
August of 2019?
No, I did not. I think the report speaks for itself. So I don't know why you want to go.
Please answer the question.
Yeah, no,
September of 2019, did you make any payments?
no,
October of 2019, did you make any payments?
no.
In fact, referring to the AG's report, which we're talking about, there were no payments made on this account until March the 29th of 2021. Is that right?
so what Skinner's basically getting him to testify to that despite the order being issued, I think they said in the most recent order being issued in May 2019, where at that time he already owed about $15K in child support. He had made almost zero payments until what he said March of 2021.
That's right, and that's because the AG had agreed that I did not have to pay anything till the appeal was concluded.
But the court order says you got to pay.
But the court order was under appeal, and the superseded bond had been posted, and the superseded bond actually stays the order for the duration of the appeal. You should know that.
Only if it's paid in a sufficient amount. Would you agree?
And it was paid at a sufficient amount at the time of the appeal. I paid the exact amount that was due at the time of the appeal to the dollar.
Okay, there was a payment received on March 29th, 2021, correct?
March 29, correct.
And that was an intercept of your federal tax return. Is that correct?
That's right. It's a garnishment of the tax refund that was due to me. Yes.
Okay. We go to the last page of that exhibit.
Mhm.
The collection amount on May the 9th of 2022, right? 482?
May the 9th of 2022. Yeah. Mhm.
Okay, and then get all the way down. You finally made a payment November 17th of 2022, correct?
Of $1,045, correct.
And a second payment was made just recently, December the 5th.
That's correct. $1,045.
Okay, now the Attorney General's records show that you owe a total of $34,235.58. Is that correct?
Yes. That's what it says in the bottom right corner.
Do you dispute that amount?
I don't dispute that amount. No.
Okay. Now, the court order that you got on appeal said you were supposed to make monthly payments, correct?
Thank you, Deacon, for the $50. Okay, already are sure it's different for civilians. At my job, we withhold if a claim for apportionment is made from the date of the request until the magistrate decide to avoid all this. Decision is in their favor, the funds reimbursed. That's generally does happen in that jurisdiction. But where if it's permitted, the thing is that it has to be usually in the order itself. If the party wants to appeal the existing support order, the court may say, if the party timely files an appeal, payments can be suspended pending the results. But generally, you gotta be paying while the matter's on appeal.
The court order was under appeal. Yes, the court order did say I paid the. Pardon me.
It states you're supposed to make them on the first of each month until the amounts are paid off, right?
Provided I have not appealed the court order, which I had appealed, and filed a superseded bond
You
to stay.
understand under the Texas Family Code.
Mr. Skinner, do not interrupt the witness.
So if I finish responding to that question, yes, we already agreed that the court order said $1,045 per month, and the payment was not made because I filed an appeal, posted a superseded bond, reached an agreement with the Attorney General's office that I don't need to pay till the appeals court made a ruling on the appeal.
Hearsay, any agreement he might have reached with the AG.
Let him complete his answer, and then you can lodge your objections and a rule on them.
Okay, I as I mentioned, I did not want to just not pay after filing the appeal and posting the superseded bond. So I am the one testifying under oath that I conferred with the Attorney General's office regarding what I should be doing under those circumstances. And the Attorney General's office confirmed to me that till the appeal.
Again, let him complete his answer. I know he's engaging in a filibuster. I will consider the objection when he finishes his answer.
I'm not trying to filibuster, Judge. Let me just finish the answer. The answer is that on advice of the Attorney General's office, I chose not to send any payments.
Your objection, Mr. Skinner.
It's hearsay, Judge.
Agreed with all the conversations with the Attorney General referenced in the foregoing answer is hearsay. Sustained.
I would then ask Ms. Bedard, who's here, who may be able to confirm why is it that the Attorney General's office took no action whatsoever between the dates till current date.
Mr. Venkatraman, you are not the questioning attorney. You are a witness. You don't have the right to ask other individuals in here questions. Mr. Skinner, your next question.
Okay, now, Mr. Venkatraman, you recently refinanced your house, is that correct?
That's correct.
And you received $427,000, is that correct?
That's absolutely wrong.
So why does your deed of trust reference $427,000?
Well, Mr. Skinner, if you need to know how refinancing works, you refinance and then pay off all the debts, including the prior mortgage. You don't get to keep a check for that amount. That's silly. No mortgage company will give you that kind of money. I had a ton of debts out there. I had a credit rating just completely shot because of all the litigation that was involved in.
You had what?
He said a credit rating that is completely shot.
Right. Because of all I was attending law school, fighting this case, and I wasn't making a whole lot of money. And so I refinanced. And when I refinance, the way the financing company works is that they take your house as collateral, they refinance, and then they distribute all the proceeds to various debtors before giving me a relatively small peanuts as my part of the proceeds. The idea being was just to clear the debts. So I don't have $427,000 sitting somewhere in the bank. That's the meaning of my answer.
How much did you have left over?
About $35,000.
Where's that money?
Well, it's wherever I keep it in my bank account.
Which bank account is that?
It's in some bank account.
Okay. can't really you got to be kind of upfront and open about your income and finances, especially if you owe a fair amount in child support. Just really quickly, thank you, Fierce Joy, for the membership, and thank you very much, Goddess, for the excuse me, for the 5 gifted memberships.
What bank do you bank with?
I bank with Chase.
All this, so this $35,000 is sitting in your Chase bank account.
Whatever is left of that was what I got, and I've been spending that since. It may not no longer be 35,000. That refinancing happened in August.
August of
And
2022.
Mr. Skinner, I've given you some leeway here, but this is not I'm not going to let you engage in collection questioning on this witness. You can engage in your motion for enforcement.
So you agree that you owe $34,258.59 in back child support?
Just to be clear, that portion of it is the actual arrearage, and I think you yourself have mentioned in your motion, a portion of it is actually the interest. Yes.
And you understand that interest under the Texas Family Code is considered child support?
I believe so. The only question I would have regarding that is if the order was effectively stayed by filing the appeal and the supersedes bond, then maybe the interest may not be required to be paid. I'm not 100% sure about that, but I am certain about the arrearage of which is around $27,000 or $28,000. Yes.
Do you not consider your child support to be a debt?
Well, absolutely, I consider it to be a debt. Yeah.
Then why didn't you pay it out of your mortgage loan?
Because I don't get to decide what gets paid out of my mortgage loan. The guy the entity who's giving me the mortgage, they identified all the debts on their own, and they said, we're going to pay all this off before we give you the money. And they did not identify the child support debt. And even the child support debt was not due because I had appealed it with the supersedes bond. But they never got into it. They never found that out. No.
Huh? Oh, did they pay off your car?
They did. Absolutely. There was a car loan which they paid off. Correct.
So the one the TD Finance was paid off.
That's right. Everything was paid off. They paid everything off.
Everything but your child support.
Correct. That's their choice. They decided who they'll pay and who they'll not pay.
Now, you know, the Texas equity, a loan under the against your home equity, you know, your mortgage company cannot dictate to where those payments go.
Yep.
I'm not familiar with that. They just told me, if you want this loan, we will pay off all these people. Otherwise, you're not getting the loan. So I didn't have a choice. So I got whatever is remaining after that was paid off, and that's what I'm using now month to month. So I got around $30,000, of which I am paying monthly $5,000 to $6,000 over and above. To pay for my expenses.
Okay.
How much is this payment on the mortgage? How much?
How much is your monthly mortgage payment?
1 moment. Can you please repeat the question?
How much is your monthly mortgage payment?
It is monthly. They also take the principal, interest, and the taxes and insurance. All that put together is $3,224 approximately. So that I'm paying out of the money they gave me. I'm paying them back every month. The
3,000 what?
I believe it is. If you want an exact number, I need to look it up. But I think it's 3,224.
I'll pass the witness, Judge.
Mr. Vengatraman, you may cross-examine yourself, in essence, by providing testimony at this point if you wish. You may also, if you wish, choose to make any testimony you wish to give during your case in chief, or you may choose not to testify anything further. It's up to you.
I will cross-examine myself, as you call it, Your Honor, and answer some of the questions. So,
because you are not questioning yourself, because you're not asking questions, you are directed by this court to testify in narrative form. Okay. Make a declarative statement, stop, to give a chance for objections. Make a declarative statement, stop. Continue that on. You may proceed.
Thank you, Your Honor. So I am acknowledging that there is a court order of May of 2019, not disputing it. I'd also like to point out to the court the relevant part of the court order, which is page number 24. And it says there, in para number 3, it is further ordered that if Venki Venkatraman has not paid this judgment of child support arrearage in full before the termination of his child support obligation in this cause, Venki Venkatraman is ordered and can continue to pay the judgment by paying 1,045 monthly on the first day of each month thereafter until the judgment of her child support arrearages and all accrued interest is paid in full. So I'd like to first of all point out that my child support obligation ended as of May of 2020. That is the month when my younger daughter graduated school. So technically, I would have been continuing to pay the amounts, whatever was the arrearage, till it was paid off. The whole idea was the arrearage should be paid off at $10.45 a month. I would have done that, but I conferred with the Attorney General's office, asked them, hey, you know what, I got this appeal going. I have a superseded bond in place. What should I do? Is it okay if I not pay, or what is more importantly, what is your office going to do? And Attorney General office has got massive powers. They can screw me up completely if they wanted to. So I would never have stopped paying without getting their blessings. So I have it in writing through correspondence, which is obviously hearsay. But the fact is, I did not pay after my younger daughter emancipated, which was May of 2020, because we were waiting for the appeal to end, which is not yet done. And the Attorney General office did not take a single, whatever Mr. Skinner is trying, the Attorney General's office could have done way worse to me if they had chosen to, if they believed that I had no grounds to not pay. Because the mission of the Attorney General's office is, which you probably know already, is on a mission to make sure every child receives the support they need and deserve. So the fact that they have not chosen to do anything, which is clear from the record, is because there was an understanding with the Child Support Division that you need not pay till the appeals court, all the appeals are resolved in the mandate issues. And I'm sure Ms. Bedard knows this. And so after Mr. Skinner filed his enforcement action, despite there being no mandate, again conferred at the highest levels of the Child Support Division, including Kathy McMichael, who's the head of the Child Support Division, and her subordinate, Melissa Smith, as to what should I do. They said, if you comply with and pay $10.45 a month, we are okay with it, because that is what your order says. So I paid that. So essentially, I'm in compliance. I mean, I have not just run away somewhere and stopped paying. I was all the time engaged with the courts, unlike, say, a deadbeat dad who just chooses not to pay. And I'm very happy to pay. I'm happy to send money directly to my daughter.
Okay, so I want to say right now, I feel like context is needed. A basic search will find that these two, the husband and wife, well, I think it's most of the husband. Actually, I think the vast majority of it's the husband. He's been fighting tooth and nail with regards to custody and payment for a very, very long time. So his, based on just a basic search, reveals that this guy he's full of it, in all seriousness.
Through the TX, to the Child Support Division, every single penny that I owe, but I cannot pay a lump sum amount. It will be very difficult to hand over such a lump sum, and then I'm going back into debt. And I am happy to, if the court signs an order which says you'll be in contempt if you don't continue to pay $10.45 a month, and I'll continue to do so. Like clockwork, I'll pay it. But this whole idea that I'm somehow the kind of remedies that Mr. Skinner is looking for is, I believe, totally uncalled for. So if I may refer to his motion, which I have it right here. One moment. A few things I need to point out, which is beyond the pale. He is asking that in item number 8, he says, in violation of the order signed on May 6, 2019. Mr. Venki Venkataraman failed to pay court-ordered child support as follows. My position is I didn't violate it. If I'd done no appeals, no nothing, and not paid, that would be indeed a violation. Then he says he's asking for a cumulative money judgment of the arrearage and accrued interest. There is no provision in the order that is currently exists to pay a cumulative judgment. There's only a requirement to pay 1045 a month. So in effect, he's asking for a modification. And I would like to remind the court that I was in your court on September 15th asking for something similar, like a judgment where I could make payments at a certain rate, but it was different from what was in the order. And the court said that I don't have the plenary powers to make such an order at this time because you're still under appeal. So you would not take that up. I would like to remind the court. So he's doing exactly the same. He's asking for a brand new order with a consolidated amount, which I don't believe is supported by the current order. Then he's asking that I go to jail if I don't pay and stay there for 175 days, which essentially means I'll never run another dime again. He wants me to go for 8 years in probation or something. And then he says I need to stay there, pay a $36,181.89 in charges. He just come up with this number. I don't think that number is even right, without which I should be in jail. And then he asked me for my driver's license to be suspended.
All right, Mr. Venkataraman, you're going more into argument than testimony.
Yeah, he is.
Okay, sorry, I realized that.
Give me facts in testimony, and then let's bring your testimony to a conclusion.
Okay, sorry. I think I realized I strayed away from the testimony. Sorry about that. So continuing with my testimony.
Yeah, okay. Well, I hate to pause it, but I think this is actually a very important point here from a court where he actually filed a challenge to his previous modification. As you guys recall, there was a existing order, May 6, 2019 existing order. He challenged it, as a matter of fact. And this is from the Court of Appeals. Yes, the Texas 5th District Court of Appeals. Not the federal, but the Texas. And I think it's very interesting here where he says, where was it? In his counter petition, father did not request a reduction in the amount of child support or plead any facts identifying specific circumstances requiring such a decrease. Nevertheless, father contends there is no evidence to support the trial court's finding of fact that, quote, the tax returns submitted by father were not credible, with father stating that the tax return program made all of the tax return program. Do you see how he kind of deflects a lot of these decisions and a lot of these things? At first, if you guys recall, he said, oh, well, the loan company, when he got the loan company made the decision as to what debts to pay. When I'm fairly certain that child support is extremely high on the priorities list in terms of outstanding debts. And then next he's saying in this quote, in his argument at trial for the modification, he said, oh, well, his tax act, they told me that my income was zero for these 2 years. However, but then he says, on appeal, father contends the only relevant evidence related to his finances was 2016-2017 returns, which showed his income is zero. So based on that evidence, his child support obligation should have been reduced to zero. On both tax returns, father reported his wages, salaries, tips, etc. as zero. However, this is contrary to father's testimony that he had income from some consulting work and renting a room in his house through Airbnb. The trial court found that these tax returns were not credible, and we defer to the trial court's credibility determinations. So, yeah.
My testimony is essentially that the child support arrearage itself is around $27,000 or $28,000. I agree with that. So it is $895 times 35 months. And that's a specific amount, less the two garnishments that happened, less the two amounts I paid. And I don't think there's any dispute regarding the arrearage itself. There is also interest that accrued on that. I am not disputing that at all. And I don't believe any attorney fees are entitled to Mr. Skinner because I'm not in violation of the order. I'm paying at this time, paying to the satisfaction of the Attorney General's office. And the period I didn't pay was the period when I had an ongoing appeal. I filed a superseded bond. It's not that I just disappeared and I said I'm not paying. I was engaged with the court system the whole time.
Okay. You pass yourself as a witness?
I do, Your Honor.
Mr. Skinner, any redirect?
Not at this time, Judge. I need to call my client.
All right, I'll give you that opportunity here in just 1 minute, because I now have all the parties here on DF 21-14758. Mr. Bagley.
Those the new people who just arrived are actually from the next case.
I do.
Please state your name.
Jyoti Masureka.
Ms. Mazureker, welcome back to the 256th District Court. Mr. Skinner, she is your witness.
Ms. Mazureker, you were divorced from the respondent in 2004, correct?
Correct.
And then the court entered an order on May 19th, 2019, or maybe 6th, I'm sorry, May 6th. And Mr. Vicky Trauman is ordered to pay you child support in the amount of $895 a month. Is that right?
That is.
And that was due and payable on the first day of each month thereafter.
Right.
And did Judge Lopez enter a judgment for unpaid child support in the amount of $15,215?
He did.
And Judge, you've already taken notice of the order. Now you heard testimony from the Attorney General's pay records, right?
I did.
And are you in agreement that Mr. Vicky Trauman owes you $34,235.58?
And there it is. Polls closing. $34,200 something odd dollars.
That's correct.
And did he pay you any child support from January 2008? I mean, December 1st of 2018 through May 1st of 2020?
He did not.
So he missed every payment in there, even though he was court ordered to pay you. Is that correct?
That's correct.
Okay. Are you asking the court to hold Mr. Vicky Trauman in contempt?
I am.
Now, are you asking to report to the court's probation officer?
I am.
Okay. Are you asking the court to suspend his driver's license because he failed under the current payout agreement that Judge Lopez gave him?
I am.
So the important dates were June 1st, 2019, correct?
Yes.
June 1st, 2019? He didn't pay?
No.
July 1st, 19?
No.
August 1st, 2019?
No.
September 1st, 2019?
No.
October 1st, 2019?
No.
November 1st, 2019?
No.
December 1st, 2019?
No.
January 1st, 2019?
No.
January 1st, 2020?
No.
February 1st, 2020?
No.
March 1st, 2020?
No.
May 1st, 2020?
No.
You're asking the court to hold Mr. Vicky Trauman in contempt for those violations from June 1st, 2019 through May 1st, 2020.
I do.
You're asking the court to confirm all your child support arrearages
I do.
and the accumulated interest as child support.
I do.
And we know he put up a bond even though it was insufficient, correct?
I do.
You're asking the court to order the release of that bond to you to start paying down on what the money he owes you.
Yes.
You're asking the court to put Mr. Vicky Trauman on probation and report to the court probation officer.
I do.
You're asking the court to order Mr. Vinkie Trauma to pay a fine to the child support office in the amount of $500.
I do.
Asking the court to order Mr. Vinkie Trauma to pay monthly probation fees to the Dallas County Child Support Office.
I do.
Haven't got there yet. And the last but most important, are you asking the court to order Mr. Vinkie Trauma to pay your child support fees, attorney's fees?
Yes,
Okay.
absolutely.
And they're enforced as costs and enforceable by contempt. You understand that?
I do.
And that would be under Texas Family Code 157.167, a requirement for attorney's fees and costs, correct?
Correct.
And you agreed to pay me $350 an hour for the enforcement, is that right?
That is.
And we've been to court, what, 4 times now in this case?
Yes,
And I advanced all the cost money in this case, is that right?
that is.
Filing fees and the service fees and the fees for the motion for substituted service at his house?
Yes.
Okay. And originally, we asked that the court order him to go to jail for 175 days.
As a last resort, yes.
Yeah, but you're willing to agree that his commitment could be suspended provided the judge orders him into a payout agreement and pays court costs and fees and attorney's fees, right?
Correct.
And you believe it's appropriate that he be held in contempt of court?
I do.
Pass the witness, Judge.
Cross-examination?
Thank you, Your Honor. Just to get the facts right, were you divorced in 2004?
We were
As you said.
separated in 2004.
Wasn't divorce decree signed in 2005?
Correct. Started in 2004.
But you were divorced in 2005, correct? You're asking that I pay a fine of $500 to the child support office, correct?
Correct.
What would be the purpose of that fine, according to you?
My attorney has the details.
Non-responsive, Your Honor. Objection.
Overruled.
All right. The next question. You're asking me to pay monthly probation fees to child support office. Do you know what would be the purpose of that?
I don't accept that it is necessary.
I didn't follow your answer. Can you re-answer that question?
I said, I don't know the details.
So it doesn't matter one way or the other whether that is required or not, according to you, correct?
That's incorrect.
Okay, then let me ask you this question. Is that you believe that monthly probation fees is going to accrue to you?
I don't think so.
So what would be the point of me paying that amount? Wouldn't it be better I pay it towards my daughters?
I don't make those decisions.
But you're asking for it, right?
If the fees are due to a certain department, they need to be paid to the certain department.
So you're still asking for the fees, but you're not exactly sure what they're for, correct?
Correct.
Okay. So you're asking for attorney fees, right?
Correct.
When was the last time you paid Mr. Skinner?
Objection, relevance.
What is the relevance, Mr. Venkatraman?
Ms. Judge, Your Honor, the relevance is, my understanding is she has not paid a single dollar in attorney fees in years, according to.
Yeah, I don't know what the relevance is. Whether or not she's made a payment with her attorney, in my opinion, is irrelevant as to whether or not he's been paying his obligations.
Responses to discovery in other cases.
Okay, but the payments aren't relevant to the recovery. So what is the relevance?
Well, if my sense is there's some understanding between Ms. Masuraker and Attorney Skinner, due to which he's been pro se for her and as a result of which he never agrees to settle any matter over years because she's got free legal services for an unlimited period. So that's why I'm asking her when was the last time she paid him.
I agree with Mr. Skinner that it's not relevant, but I will allow her to answer that question that you just stated at the last of that. When is the last time she paid him?
Okay.
I would have to I would have to look up and see. I don't recall.
Okay.
So would it be true that it's not recent, nothing recent?
Correct.
Okay. You're asking for my driver's license to be suspended, correct?
As a last resort, yes.
How do you believe that will help you in getting any payment if I'm sitting at home unable to drive?
It's not about helping me. It's about making you comply with the orders.
That's what I'm asking you. How will me not having a driver's license make me comply?
I don't know.
Okay. Do you know that the suspension of a driver's license is it is something that the judge may do? It's not the judge has to do.
Want to object, Your Honor?
Yeah, I was also going to would say that this is objectionable, calling for speculation as to what she thinks the judge is or isn't going to do, and ultimately it's a legal conclusion that the judge is going to make as to whether or not he's going to suspend his license in order to get him to start paying.
Honor, he's asking to speculate and also to a legal conclusion. She's not a lawyer.
Sustain.
Okay. Are you aware of are the children having any need, or are they any distress at this point financially?
Judge, I'm going to object to relevance.
Also
to that as
objection.
well.
Also object.
For the record, I'm going to note something that everyone here knows, but just so an appeals court, if necessary, needs to hear it. The youngest child is now 22, and so therefore there is no relevance to that question.
Okay.
And she is emancipated, she is out of high school, etc.
Yes, at this time, they've been fighting for so long that all the kids are now emancipated. The problem is he still owes the child support. I don't understand this logic that I've seen from deadbeats talking to other deadbeats, lamenting how, oh my God, I'm 65 years old. You know, my kids already have their own kids and I still owe child support. Like, dude, you weren't paying. Just because the kids are out doesn't mean you still don't owe. Because guess what? Mom or dad had to carry the weight while you weren't paying.
The court parties all know that. So
Okay.
I will sustain the objection.
Okay. Are you intending to get any funds that you're receiving from me, all a part of it, to the children, or you're not going to get any of it? They're not going to get any of it.
Once again, it goes.
Again, objection. It's not relevant whether or not they're going to get any of it at this time. The issue is that mom has had to pay his share because he wasn't paying. She had to carry that burden.
Beyond the pale of this hearing, Judge.
Sustain.
Oh, there is absolutely insane lane. Yes, there is absolutely interest on overdue support.
I have no further questions. Yeah.
All right. Redirect.
Nothing further from this witness, Judge. I call myself on attorney's fees.
All right. Please raise your right hand. You
Your Honor,
swear-
before he does that, do I have an opportunity to make arguments? He said I could do that later on, but not as part of my testimony, right?
He's still in his case in chief. So
Okay.
do you solemnly swear or affirm that all testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Judge, and as an officer of the court, I do.
All right. And please identify yourself for the record.
Stephen D. Skinner, State Bar, Texas State Bar 00789-811.
Welcome to the 256th District Court. Is Ms. Goss going to question you, or are you going to testify in narrative?
I'm just going to testify in narrative, Judge.
please confine yourself to declarative statements with a pause after each statement so that there's time for objections.
Danny's asking, is the lawyer testifying? People in the chat were saying that, asking that too. Yes, he's testifying as to his attorney's fees, which is actually something I'm not used to seeing personally. Usually in New Jersey, applying for attorney's fees is usually done through a written application. Sometimes there might be an oral argument as to attorney's fees, but they're usually done on motion or through an application, and not through the attorney directly testifying in the middle of in the midst of the hearing.
You may proceed.
Judge, I'm a licensed attorney in the state of Texas. I'm familiar with the fees charged in North Texas. I've been practicing law since May of 1994, and I've done hundreds of contempt cases. This is not my first rodeo at doing these kind of cases. My client has incurred cost of $522, $196 twice. We refiled this once. We were unable to get Mr. Vicky Trauman served, so we refiled it. So we got $522 in cost. And attorney's fees, she's incurred $4,340 in attorney's fees. That's a total of 12.4 hours. And I assure you, I spent more than 12.4 hours on this contempt matter. I spent 5.5 hours preparing the original petition for enforcement. On November 3rd of this year of 2022, I've spent another 4 hours where I prepared our amended petition. I had to prepare the motion for substitute service. We had numerous
And there was much rejoicing.
discussions with our process servant. I've got another 2 hours where I prepared and appeared for the last initial hearing in this contempt hearing. I've got another hour and a half on the second hearing, and that doesn't include any time for today, Judge. I prepared and gave you a proposed order, and so that's a total of 12.4 hours in this particular case, Judge. So I've got $4,340 in attorney's fees and $522 in cost. And these are all enforceable pursuant to Family Code 157.167, which provides for attorney's fees and costs and enforcement and contempt action code. Huh?
Thank you for the $5, Goddess.
Oh, and Judge, the Family Code provides that those fees can pay directly out of his supersedious bond that he paid into the court registry. We'd ask you to order those to be paid from the bond, and the amount that's left over can go towards his child support arrearage. Pass myself, Judge.
Cross-examination.
Thank you, Your Honor. Is it your contention that the superseded bond can be disbursed even before a mandate is issued by the Supreme Court?
I do in this particular instance for enforcing child support.
So what would be the ramification of having a superseded bond which disappears before the mandate is issued?
Well, your bond is insufficient to the amount that you actually owe. It's only a portion.
It's not a question of the
It doesn't stay the litigation.
All right.
It's not okay. This is not intended to be a back and forth here. So the judge needs to rein both of them in.
That's not cross-examination. That's a legal argument as to whether or not the court can order the supersedious bond released.
Okay. Again, asking you, Mr. Skinner, the same question. When was the last payment you received from Ms. Masureko?
I don't have any idea. It's been 3 or 4 years.
So you're saying in 4 years she has not paid you a single dime?
I would say she hasn't, and I would object to relevance of the question, Judge.
Overruled.
Yeah. So can you answer the question, Mr. Skinner?
She hasn't paid.
And when was the last time she paid you?
I told you I don't remember. It's been a long time ago.
So how much litigation has happened between then and now?
Well, I can't tell you. This is the most litigious case I've been involved in 30 years.
And based on a cursory Google search, he's not exaggerating all that much, if at all.
So
There's actually a lot from a basic Google search involving these two.
what stopped you from just settling the case and moving forward rather than litigating for free?
Sometimes you have a duty to your client. She's entitled to legal representation. If I didn't do what I did, you wouldn't be paying anything now.
I appreciate the commentary there.
Is it because that you messed up the court order and left out the child support for Smriti, and you were facing a possible malpractice suit
Okay. Yeah. No. Oh, here we go.
due to that?
We're not. No. I gave you leeway to go down this line of him being paid, but now you're relitigating something else.
Okay.
I'm not going to allow that.
All right, Your Honor.
Thank you for the 100 bits, Mandy.
Who was the process server you hired to do the service?
Michael Fennell.
Michael what?
Fennell.
Can you spell that, please?
Fennell.
Do you know at what time he posted something on my door with a substitute service order? Do you know what time it was?
I don't remember.
Is it possible that he didn't write the correct time on the substitute service order that he stuck on my door?
I have no way of knowing. You asked me to speculate.
All right. And somebody is talking in the background here. I cannot make out what it is.
Well, I tend to agree. If Ms. Goss is going to talk in the background,
She's not in here, Judge.
whoever it is, then it's distracting. Conclusion.
Okay, just last couple of questions. Is he there? So can you tell the court how exactly you served your amended petition in this matter?
Served it on you through the e-filing because you'd appeared in court by then.
Right. Just that was the question. If I did it by e-service?
I did.
Okay. No other questions, Your Honor.
Redirect.
For myself, Judge, no.
Call your next witness.
Judge, I'd like to rest, make a closing statement.
You'll get a chance to make closing statement. Mr. Venkatraman, call your first witness.
I'm calling myself, Your Honor.
All right. Is there more testimony you wish to give besides what you gave previously?
Yes, before I go to arguments, I have a couple of other things I want to make as testimony.
All right. You're still under oath.
Thank you, Your Honor. So this substitute service order was stuck on my door in this case. It mentioned a 9 o'clock time at which it was stuck on my door. And at 9 o'clock, me and my neighbor were at home. And then when he left, I opened the door. There was no order stuck there. It was around 9:45. So that substitute service order was not stuck on my door at the time stated. So it had a false information in it, which I would like to point out that I had no idea when it got stuck on the door, but it was there after I returned from the court on the following day.
So, if you didn't hear that, he's now challenging the service of process by saying that somehow the order or this the service was hidden somewhere, not on the door that was left for him, and it's such a weak sauce argument. And yeah, this guy.
So there's something wrong with that timing that was mentioned there. The other thing I want to mention is that the process service, as mentioned, he tried to contact me 3 times or reach me 3 times, and each time the lights were out, and one time he saw me through the blinds. And I also mentioned in my objection that if the lights were off, I was not there, and nobody can see me through the blinds because the blinds are always closed. I don't keep my front blinds open. Uh,
The problem is that given how many probably how many hearings they probably had on this before we're finally here, because this is a challenge for him not paying 2019. He would have had to have brought this up a long time ago and probably failed already through motion or through argument. He already mentioned that he objected to it earlier, but he's relitigating it again here and now. And of course, Danny mentions doesn't change the fact that he still owes $35K. That's on the record. It's on the record that he owes almost $35,000 in child support. I mean, the improper service may have been relevant, but not at this stage in the game. It would have been the first thing he would have objected to from the outset. Would be the objecting to service of process, not here at the actual hearing.
All right. Are you passing yourself as a witness?
Not yet, Your Honor. I'm just sorry. I'm just looking up something here. One moment.
I will say we should be able to get through the end of
I'm
it.
also testifying that the superseded bond I filed, the amount was specified in the docketing statement, which was accepted by the Court of Appeals, and they did not indicate to me that there was anything wrong with that amount. That amount was based on the amount of child support owed at the time of filing of the appeal, which was sometime in May of 2019.
Okay.
And I'm going to argue that the services were not proper, but that's part of my argument. It's not my testimony.
Very good. Cross-examination.
I got a quick question about his income, Judge. During this period of time when you didn't pay child support.
Go ahead.
Did you receive any government payments?
No.
You didn't receive $42,000 from the federal government?
Not to myself, no.
There were paid for Zenith Mediations?
God damn it. I swear to God, I need to turn off super chats sometimes. I'm so sorry to all of you. Thank you, Whiskey77, for the $100. Thank you, guys. But all right, let's continue on. But this is actually a relevant part. Thank you very much.
One was to you personally, and one was to Zenith Mediations.
Pardon me?
One was to you personally, and the other one was to Zenith Mediations.
I don't recall. My recollection was both were paid to.
So I'm gonna long story short, what this line of questioning is that the attorney is implying that Mr. Venkatraman may have committed PPP loan fraud
Towards Zenith Mediations. That was my business entity for a while.
And on your application for these loans, you listed that they were to pay payroll. Is that correct? Salary?
Yes, that was myself.
What staff do you have?
I am the staff.
You have a staff?
Pardon me?
You have a staff?
I am the staff. I just mentioned that. I was eligible for it as a sole proprietor and the sole employee.
Because if you're the sole employees, that money was actually came to you individually.
I don't remember how it came, but that was the way I applied for it, and it was approved, and I got it.
And you got approximately $42,000.
About 3 years ago, I think. Yeah.
But you didn't use it to pay your child support, did you?
No, I did not. I used that to pay other expenses to survive.
In fact, paying your child support has never been high on your priority, is it?
That's
that's a very snarky comment a snarky question by this by a lawyer. Like, so paying child support is not really on your priorities list, is
Not
it?
a true statement.
All right. I don't need any more on that.
Y'all pass the witness, Judge.
Redirect of yourself.
Yes, I would like to make my legal argument at this point.
No, we'll get to arguments here in a minute.
Okay. Oh, redirect
Redirect.
myself. Okay,
All
sorry. Lost track of it.
Call your next witness, Mr. Venkatraman. Are you
Myself.
resting?
No, I would like to redirect and respond to some of the things he said.
No, I don't. You're not
Okay.
getting it. I mean, I'm going to give you the leeway to, if you wish. I don't need to hear anything more about the PPP loan or whatever it was.
All right. The only point I would make is he's trying to keep on insinuating
No.
that.
Testimony.
Okay. I rest as far as testimony is concerned.
All right. Mr. Skinner, close.
I close, Judge.
I'm going to give the parties 3 minutes aside on closing. And then I have a question. 3 minutes. Mr. Skinner.
Judge, I think we've made a compelling case to hold Mr. Venkatraman in contempt. A contempt finding is like a deed of trust. It's going to make him pay. If he's not held in contempt, he's not going to pay. He's exhibited to the court from November of 2018 that he's not going to pay his child support. It's only after we brought this case that he started paying his child support of $1,045. He's been in default under that payment order from Judge Lopez all the way through this last month. The AG's payment record is accurate on the amount of money he owes, including accrued interest. We've got child support that he hasn't paid. We've asked the court to hold him in contempt. We've asked the court to order him a report to the court probation officer. That's standard procedure for Dallas County Family Courts. The fine that we've asked Mr. Venkatraman to pay of $500 is a fine that was instituted probably 10 years ago, maybe longer. And the general rule was that if somebody reached an agreement, they only had to pay $100. But if they fought it all the way through a hearing, final hearing in the case, they had to pay $500 if they were held in contempt. The probation fees we've asked Mr. Venkatraman to pay are ordered to help defray the cost of the probation officer, Mr. Brown. He's got an office there on the 4th floor. And the respondent probationers have to report to his office once a month and comply with the court's order and show they're in compliance with what they're ordered out of this hearing. Ms. Mazuraker agreed to pay me $350 an hour. That 13.4 hours I testified to, I forgot to include that 3-hour mediation we just did. So if I go back and reopen that testimony, we're gonna request a greater fee for attorney's fees. And we ask that you order that amount in attorney's fees, court costs, hold him in contempt. We ask that you order that supersedious bond to be released, and it can be reused to pay attorney's fees and costs in this type of a proceeding. His appeal bonding file was always insufficient, and that had to be set by the court. He can't just arbitrarily set an appeal bond. We'd ask for contempt finding and a judgment for $34,258.58 for Ms. Mazuraker, and attorney's fees and costs. That I testified to $4,340 in attorney's fees and $522 in cost. That'd be $4,862 total on costs and attorney's fees, Judge. We'd ask that the arrearage be confirmed, that he be ordered to pay that, and interest per the family code is 6%, simple interest. We really ask that he pay a larger amount as a down payment to stay out of jail. He's got the money, he's just hidden it all this time, Judge. And we'll close and rest.
Mr. Venkatraman, 3 minutes.
Right. So quick responses to some of the things he just said before I make my argument. One is that
that was his argument. You have 3 minutes to make your argument.
Okay.
Use as
I do not believe a contempt rule finding is appropriate. I've never exhibited that I will not pay, and unless I'm threatened, I will pay with contempt. I gave you a logical reasoning why I did not pay so far and why the logical reasoning why I started paying. All that has been completely ignored by Mr. Skinner. He seems to think in a vacuum, as if there was no appeal, there's no concurrence with the Attorney General's office, as if this is something isolated. It's not. There's a lot of other things that I've just mentioned that went on. Second thing is with respect to contempt. Contempt finding requires that I'm not in compliance, and I would argue that I am completely in compliance of the order. I have started paying the amounts due as per the order. So you can have a contempt finding only if I'm not paying as per the order, which I am. He is asking for a contempt finding based on paying a lump sum amount, and that is not appropriate. So I have argued that, and I would like to bring the court's attention to the same spreadsheet from the Attorney General's office that has the amounts, and it also indicates that they took absolutely no action whatsoever during this period, and that implies that they are in agreement with me.
Well,
then with respect to
I appreciate the OAG's raising your eyebrows at that comment. Oh, the fact that the Attorney General took no action against me means, implies that I'm right. And she raises her eyebrows like
during this period,
and that interesting.
That implies that they are in agreement with me. And then with respect to referring to my amended objection that I filed, I would like to point out a few things from there. First thing being, again, that I am in compliance. I have been paying. I started paying without any threat of punishment or anything. I started paying because it was appropriate to pay because my appeal was coming to a conclusion. It is not concluded, but it's coming to a conclusion. I started paying ahead of time, even before the appeal. Appeal will just affirm that order. Appeal will do nothing but affirm it. Appeal is not going to change. I mean, the mandate will just say that order is affirmed. And that order's affirmation is just that you pay $1,045 a month. That's what it says. The appeal doesn't have going to say ask him to pay the whole thing in one go. And the second thing is, again, as I pointed out, you cannot disburse the supersedis bond until the appeals court issues a mandate. Otherwise, if in the event I prevail in the, you cannot say 100% I will not prevail. If I prevail, then you will find that the supersedis bond is already gone. It's not there. So I don't believe that's the intention of the supersedis bond. Then I also point out that there is no provision for a lump sum payment in the order. There's only provision to pay monthly. So a lump sum payment would be beyond the order. He's asking for a new order, and it's a modification. There's no modification motion to be heard at this time. And the supersedis bond essentially stayed the order. And I have a quote case which I have cited in my objection. It's Cantor v. Herald Publishing Company, Inc., 632 Southwest 2D 656, 657-58, Texas, App Tyler, 1982, opinion on motion. So I believe that that stayed the order. So I did not have to make these payments, and I was in compliance. Then I would also like to point out that the service of that order was not proper. I know this has come before the court before. It was not served personally. Personal service is required for all enforcement orders where a jail time is being threatened. I appealed that, as you know. The mandamus didn't go through, and typically the mandamus don't go through because they say, put it in your appeal if you have a problem with it. That's the response, as you probably already know. Most mandamus, it's a mandamus. So it was not a proper service. It was not personally served. That should have been quashed, according to me.
The personal service should have been quashed, according to me.
Because the section 157.062 notice of hearing says clearly that personal service of a copy of the motion is required. And finally, with respect to the filing of the amended motion, the amended motion asks for far more draconian remedies than the original motion. And that requires, again, personal service. I've cited cases in the Family Code 157.005. It says that you have to file such motions in person. And
this all sounds like he already tried to challenge the service and lost. But why he's bringing it back up again? Well, we all know why. But it already sounds like this has already been litigated before. So he's just bringing it up to waste everybody's time.
and also the fact that the amended motion is beyond the second anniversary of the child support order. So it's by operation of law, you allowed the first order. You said that he filed it on the 31st, but that weekend order extended, so he was still timely, and so you did not grant me a quash on that. But the amended motion was filed way afterwards in November, so it's 4 or 5 months after the deadline has passed. It is substantially different from the original motion, meaning that that motion should have been properly served again on me, which it was not. He had Mr. Skinner admitted it was just e-served on me. He cannot do that when he's asking for additional remedies beyond the original motion. Plus, it is beyond the deadline of the 2-year deadline that was required for him to file a new motion. It's essentially replaced the previous motion. The previous motion doesn't exist anymore. The new motion is totally not timely. It's beyond this, the 2-year deadline that he is required to file by. So I would ask that his motion be quashed for all these reasons. One is and before I say that, the suspension of driver's license is asking based on section 232.003. And that says the court, he said in his filing, he says the court is required to suspend my driver's license. That's absolute falsehood. That's not what the statute says. The statute says the court or title agency may issue an order suspending a license. That's different from required to do that. It's not mandatory. And also says it's been provided and that I have been provided an opportunity to make payments towards overdue child support under court ordered agreed payment, and I failed to do so. I am actually paying. So it makes no sense to suspend my license.
Yet already the evidence is on the record, and we even heard you admit and testify that you haven't been paying, like, at all.
License, when I am in compliance, I have started paying. I've already indicated I will continue to pay. Taking away my driver's license is just going to limit my ability to continue paying, because if I can't make a living, then there's no way, or I end up sitting in jail or something, there's no way I can be able to pay anything further. So on all those grounds, on 5 different grounds, I believe this motion should be quashed. One, I am in compliance. I started paying.
I got all 5 of them.
Okay, then I won't waste court's time and repeat all 5, but that's my summary of my argument.
All right. Very good. The court has a question of the parties. Is the amount of the supersedeas bond $7,135.70?
I think it was $7,015.
Plus interest.
Huh?
Plus the interest. I don't know.
Oh, interest. Okay.
Somebody keeps talking in between. So it was 7,015 when I filed it, and it might have accrued some interest. Yes.
All right.
And we already heard testimony that at the time when he tried to challenge this, first tried to appeal this, he had owed $15K. So that's less than half of what he allegedly owed at the time of the modification of the May 19th order, or excuse me, the May 6th, 2019 order. So he's nowhere even close to putting up the bond of what he owes.
The court will issue the following findings of fact and conclusion. Well, before I state those, I'm going to note for the record, this litigation has been ongoing since July 2004. It is almost 18 and a half years old.
Yep.
It has been to the Court of Appeals no fewer than 19 times.
19 times with the Court of Appeals.
That's what I know about. It has been to the Supreme Court 4 times just in my tenure on this bench, which began June 17, 2022. Almost every judge on the 3rd and 4th floor of this courthouse has been recused from this case at one point or another. Most of them voluntarily. It is time to bring this litigation to a conclusion. It is in the interest of the public that this matter be brought to a conclusion. It is in the interest of the parties that this matter be brought to a conclusion.
And the taxpayers, and the taxpayers for the state of Texas.
I'm going to issue the following findings of fact. I'm going to dictate them into the record. I have scribbles here that I hope I can repeat these verbatim, because I'm going to turn them into a typewritten signed findings of fact and conclusions of law. that will be issued before my time on this bench ends December 31, 2022. My effort here, now strike that. My intent here is to do justice, serve the party's best interests and the public's best interests, and if at all possible, to bring this litigation to an end. The court finds the following facts: that Venki Venkatraman is in arrears on child support in the amount of $34,235.58 in the amounts and on the dates outlined in Mother's Exhibit 2, which will be attached to the written finding of fact.
There it is.
That the evidence supports a finding beyond a reasonable doubt that Venki Venkatraman has acted in contempt of this court's order dated May 6, 2019. 3, that Jyoti Mazurekar has incurred necessary attorney fees in the amount of $4,340 and necessary costs in the amount of $522, the amounts of which are reasonable. The court will issue the following conclusions of law: that the motion for enforcement is not barred by the statute of limitations. 2, that attorney's fees and costs are assessed as additional child support. 3, it is in the public's best interest. No, let me rephrase that. It is in the public's interest to bring this 18-year litigation to a conclusion. 4, it is in the party's best. Let me rephrase that. I keep putting best in it. It is in the party's interest to bring this 18-year litigation to a conclusion. Conclusion of law number 5. In the exercise of this court's discretion, the public interest and the interest of the parties are best served by not holding Venki Venkatraman in contempt of this court's order dated May 6, 2019. Number 6. In the exercise of this court's discretion, the court concludes that the public interest and the party's interests are best served by not confining Venki Venkatraman or ordering his driving privileges suspended. Conclusion of law number 7. In the exercise of this court's discretion, the court concludes the public interest and the party's interest is best served by confirming the amount of the arrears and establishing a payment schedule for the payment of the arrears and attorney fees. I will issue the following order. Mr. Skinner, I will issue an order confirming an arrearage in the amount of $34,235.58 plus attorney's fees in the amount of $4,340 plus costs in the amount of $522, which are to be assessed as additional child support. The total amount by my calculation on that is $39,097.58.
Oh, nearly 40K total.
That order is enforceable by contempt. Now, meaning, well, I'll leave it at that. The amount, $39,097.58, will be paid as follows. $7,135.70 by use of the supersedeas bond as soon as the mandate from the Court of Appeals is issued. Secondly, the balance, $31,961.88, shall be paid through the state disbursement unit at the rate of $1,065.40. By my calculation, that results in a 30-month payment plan, and you can be done with each other.
Just one clarification, Your Honor. The supersedeas bond also, can the superseded bond, if the mandate is issued, when the mandate is issued, can be paid through the TX child support disbursement unit, because that way they can record that payment as well.
It can go straight to Ms. Mazurecker. That's who the bond is payable to, I trust.
But then how would the TX to give me proper credit, because their total shows 34,000.
You will
have paid
report if it needs to be reported. You can report that to the Office of the Attorney General that it's been paid.
Patience, everybody, patience. You might get the answers to the questions pretty soon.
Okay.
All right.
Ms. Bedard has any?
Mr. Venkataraman, lest there be any doubt about this, I crafted this order and those findings of fact, and the findings of fact are supported by the evidence, but I crafted the findings of fact along with the conclusions of law for the purpose of getting the right result in this, but also avoiding protracted additional litigation.
Mm-hmm.
Understand, Your Honor.
Which I think what everybody wants. Well, except for Venki. Everybody wants this to be done except for him.
That finding of fact that you have acted in contempt of this court's order dated May 6, 2019, could result in a contempt order against you should a higher court conclude that my discretionary decision not to hold you in contempt was not supported by the evidence.
So,
all right.
I think as a member of
this is what I think is really brilliant
of the bar, although not of the Texas bar, you understand what I am saying about the risks of an appeal of this matter. My hope is that this is the final order that ever has to be issued other than the issuance of a mandate from the Court of Appeals in this case. I don't know that that's possible, but I'm hoping the parties are there now.
Basically, what the judge just said is, I am hanging this contempt finding above your head like the guillotine. And if you appeal this, and if the higher court says the judge was right in his appeal, the guillotine falls.
So,
okay, I got your point.
Mr. Skinner, I need that order by May 28th.
I can do that, Judge. Now you're talking about December?
Did I say May 28th?
You did, Judge. I want to be in Mexico then.
I want that order by December 28th. This court is having what I'm referring to as a signing party on December 28th, and I'm hoping to get rid of every outstanding order. These findings of fact and conclusions of law will be issued by that date as well.
Okay, so you're finding, I'm sorry.
All right, go ahead.
Well, you reiterated a lot of things, and I was hoping to see your findings in a typewritten form so I could amend the order I gave you earlier.
I'm going to do my best to get my findings of fact and conclusions of law issued ASAP.
Okay.
But that the order stands alone from the findings of fact and conclusions of law. All right.
Now, Judge, you found him in contempt, and then you say he's not in contempt.
No, I did not find him in contempt. I found that the evidence supports beyond a reasonable doubt that he has acted in contempt of this court's order dated May 6, 2019.
He's being very explicit in saying that while there is enough evidence to find him in contempt, he is not going to, unless he tries to appeal this and he loses. He's basically trying to cut him off from trying to constantly appeal and appeal and appeal and appeal and appeal and appeal.
Okay, and you're releasing the bond when the mandate comes down.
Correct.
And then for whatever's left over, we just had to get him to pay it, correct?
$31,961.88 payable $1,065.40 per month. If I have calculated that correctly, that's a 30-month payout. First payment due January 1, 2022. I trust the Office of the Attorney General.
2023, Judge.
2023. Thank you.
Okay.
Thank you. Thank you.
And
That's
accrues,
important. That's important.
it accrues 6% interest per the family code.
Correct.
Okay.
And that includes all accruals, that amount. So
Right.
I trust that the Office of the Attorney General will set their records accordingly. Anything further?
Nothing from my side, Judge.
Nothing from my side as well.
I can't hear you.
That's not probation.
Oh, Judge, you're not putting him on probation?
I am choosing not to hold him in contempt.
Okay.
I'm finding that the evidence supports a contempt finding. I am choosing not to hold him in contempt. In the exercise of the court's discretion, in the interests of the public and the parties.
Thank you, Your Honor.
All right.
That
Awkward
would be
silence.
excused.
I am available tomorrow if you have drafting questions. I am obviously available on Wednesday, the 28th.
All right.
All right.
I may have drafted questions.
Thank you.
All right. So that's the end of that saga. But we're not going to go into the other case because the other case is actually a pretty long. I listened to it most of the day today. So we're gonna save that for a later time. Because we're gonna go be looking at the or listening to the listening and watching to the Polyaudis case with Methany and Nathaniel. And then probably sometime maybe next week or maybe over the weekend we can hear the other custody case. But I thought this was an interesting case to take a look at. Doing the little research, you realize like this Benke guy is, another Blandino-esque character with the amount of litigious actions that he took with regards to the family court system. I mean, Chaz, he says it's a contempt charge. I believe I had to double check. I think he's barred in California, not Texas. He used to live in California. But I mean, there can be a referral if he gets an actual criminal contempt charge against the California State Bar.
And there was much rejoicing.
Hey, thank you, Taylor, for the $9.99 super chat. So that's where we're at. I wanted to keep it simple and keep it to the case at hand. So I want to thank you guys for hanging out with me tonight. I will not be streaming tomorrow, but I will be back on Friday, as per usual. But I appreciate you guys coming on to watch. I appreciate all y'all support. The whiskey Archangel. Thank you guys for your generous tips. They were much appreciated, even though they blew out my ears a bit. But I want to thank you guys again, and hope you have a good rest of your evening. And I will talk to you guys later. All right. Hit that like button on your way out, of course, and check out my Discord. See you guys. Thank you, Deacon, for the $5 tip. It sounds like a triangulation. Oh well. Okay. But thank you guys. Take care.